Today's tip comes from Jim McComas's Dynamic Cross-Examination, a whole new way to create opportunities to win. Jim is here with us today. Thank you for being here. Will you please read today's tip and talk a little bit about your book?
Sure, I'd love to, Mike. The tip is make a list of particularly good questions, phrases, images, themes, movie references, analogies, ideas that we can use in questioning the witness. Then take that list and put it in the witness file. There's a witness file for every witness. And by the way, you should have from the start of your case an opening file and a closing file for your opening statement and closing argument, and put those ideas in there too. One example is I had a case one time, it's actually a civil case, and the perfect analogy was it was the perfect storm. So I just thought of that while I was, driving in the car, wrote that down, that in there, and then later it comes out becomes the theme for the case. But more interesting, I think there are a couple of additional ideas I want to mention too. The first is that it takes a lot more courage to win a case than it does to lose. It's easy to rationalize and start making up excuses. And you've seen this when the opponents at depositions or in pretrial discovery or preliminary hearings are already making excuses about what's wrong with their case or how they sought to settle or blah, 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 come and talk to me. They're reluctant to give their all in the case. But we who represent the underdogs have to give our all in every case. Believe me, the jury is watching. One of the most notorious cases I ever did in Alaska resulted in an acquittal. And talking to a juror afterward, the juror said to me, it was such a close case, but we could see how you and your co-counsel really believed in your client. And that made the difference for me. Think about that. If you blink, the jury will see you blink. You have to have the courage to go in and just put it all out there, put everything out there. And if you lose, we all know how that feels. There's no worse feeling in the world. But if you want to win the game, you have to aim for winning the game and winning the game only. And that leads to my final point, which is the greatest limits on our advocacy in court are always self-imposed. It's not the judge in his rulings. It's not the prosecutor or the criminal defense lawyer. It's us. It's us worrying about, should I really go the next question here? Should I really make this point in argument? What will they say? What will the response be? This whole concept of self-censorship, so as not to look bad, leads to entirely the wrong thing. There used to be a school of cross-examination before dynamic cross called look good cross. That was a yes-no method. And the goal was to finish the cross-examination without having blown the case, and the attorney looks good while doing it. The client who's looking at life in prison or trying to live life without the settlement that will make medical care and rehab possible doesn't care how you look. That client wants you to win the case. And that's what we got to do.
Wow, that's very wise. I know I've found myself in the middle of trial. I catch myself thinking, what does the jury think of me? Are they impressed? And I have to just say, stop it to myself. Stop it. It's not about me. I don't care how I look. I can't care. That's not why I'm here. So that's very wise. We care about the truth. We have to, if we want to be successful. And you're right. That takes some courage. I think that's what you mean when you say it takes courage to win, courage to be there, vulnerable, truthful, credible, and not caring how you look, if it means that you're getting your point across.
To use another music analogy, it's like Janis Joplin standing in front of 50,000 people letting everything out. That's what we have to do in the court.
Today's tip comes from Jim McComas's Dynamic Cross-Examination, a whole new way to create opportunities to win. Here to read today's tip is Jim McComas. Thanks for being here this morning.
Well, thank you, Michael. The tip is by investigating, preparing, and carefully observing a trial, we determine who the witness wants to be for purposes of this court appearance. Then we flexibly use the cross-examination, and here a dynamic cross-examination, to take full advantage of the witness's predispositions, needs, and agenda. The point of this tip is that too often we focus our investigation on who this person really is in their own community. What are their pluses and minuses, their weaknesses? What would they tend to do? What psychological group, some people say, would they fit into? When in fact, when they cross the threshold in the courtroom and take the stand and the oath as a witness, a lot more things are going to be going on. Let's take an example, the opponent's expert witness. We all know who the opponent's expert witness is, down deep, a whore, right? Takes all this money in order to warp the facts, mislead the facts, or hit the facts so that they can make the best pitch possible for the prosecutor or for the criminal defense firm that's hired them. But if we attack right away on bias, we miss a great opportunity because we haven't factored in how do they want to appear to the jury. To the jury, they want to appear objective, knowledgeable, well-read. And so with every expert witness that matters in a case, we can start with a section based upon our research and our own experts' input and tomes, learned treatises in the area, and we can get them to admit that objective experts would agree with the following proposition. Because before they see the knife in the hook, they're trying to look acceptable to the jury. And then once we've got them to agree with that, we can go through their testimony and we can show how they failed to meet their own standards on this point, this point, this point. You will see this done very effectively in Appendix C to Dynamic Cross. Another interesting one, and different from that, is the sympathetic store owner. This poor guy is in his store. Some youths come in. He gets stabbed superficially in the back half a dozen times. They go running out. He gets his big .357 Magnum from under the counter. He runs out. He goes chasing in the direction that he somehow thinks that they ran. He sees a flash of red plaid at the corner. When he gets down there, he swings around and he fires off his gun into the crowd and hits and nearly kills somebody. The investigation shows that this guy is hardworking, a man of faith, somebody who is doing everything he can for his family, working 6 and 7 days, that he's the most honest person you would ever come across. And yet, we know his testimony is based on a fundamental lie. He knows he shot the wrong man. And if he acknowledges that, then he's going to sit where the client's sitting. So he can't acknowledge what he did. Now we see a tension between who the man really is and wants to be and wants his wife and children to think who he is and who he wants to be in court. And we can use the differences between those two aspects of personality or those two psychological settings in order to gain very close to complete admissions on his part by the end of the cross. See, for example, in the book, the cross at page 95. Chapter 4 contains another situation, and at page 155, there's another cross-examination, which, makes the same point. So that's the idea. Don't forget in your rush to find out who this person really is, that when he comes into the courtroom, he's going to have an agenda and a set of parameters that he thinks he'll be willing to go to and not exceed. It's different than the man himself.
Wow. That makes sense. And I love the dynamicism of it, the dynamic cross-examination, because as much as you can plan, and you can do some planning for how we expect that witness will show up in court, it really requires us to be dynamic and be on our feet, and more like jazz than classical music, I would say, as the trial lawyer, because that person might show up at trial in a way a little different than we expected, and we have to be ready to play that tune, right?
Well, you're exactly right, Michael. And it's no coincidence that in 1903, the first Bible of cross-examination by Francis Wellman was called The Art of Cross-Examination. And then 70 or 80 years later, Posner and Dodd gave us 1,000 pages of the science of cross-examination. And the truth is, it isn't art and it isn't science. It's a method of communication based on the preparation that you just mentioned. But it's the preparation that sets you free and lets you dance in the courtroom or play jazz, as you put it.
Today's tip comes from Case Analysis, Winning Hard Cases Against the Odds by Jim McComas. And here to read the tip is Jim McComas himself. Thanks for being here this morning, Jim.
Sure, Mike. Thanks for having me. By the time of trial, we know a vast amount of information about our case, but we'll only be able to present a small portion to the jury because of the rules of evidence, because of availability, because of unforeseen circumstances. But the core insight is this. Within that small portion that goes to the jury, only a few facts and circumstances will determine the outcome for either side. Well, my dear wife has drawn this chart here. Everything in black we will know, but only what's in blue will be before the jury. And in that box, this small red dot will contain what I call outcome levers. An outcome lever is a fact, a piece of evidence, a circumstance having nothing to do with the evidence or any other thing that in and of itself can determine outcome for one side or the other. The important ones to look for are the ones that aren't in the evidence, because as lawyers, we're trained to look at the evidence. Take race. Depending upon where you're trying the case, the racial makeup of who got hurt and who did the hurting may make all the difference in the world, even though neither side is supposed to address it in court. Well, we can't afford that. If we're on the losing end of the racial analysis, we have to address it in court, make it right. Another example would be high-profile cases. I once tried a case where 90% of the venue agreed that my client was guilty going in. But after a rigorous voir dire and a trial in which we had a surprise that no one had heard in the last number of years when the publicity was building up, it resulted in a acquittal for murder. So that's the concept. Once you've identified the outcome levers, theirs and yours, you then work to minimize theirs by exclusion, by evidentiary limit, by anything you can do. And you take yours and you inflate them and make them as large and effective as possible.
This seems very wise. The idea, the first part of that is just a mistake that I see lawyers make all the time. And that's, I would call it the curse of knowledge. I didn't make up that phrase, but the idea that we come in knowing so much and we want to just spill it all, and the jurors don't care about most of it. And then you're taking a step further saying, not only is there this whole big box that you drew of things that don't need to go into the case, figure out what is an outcome lever, what makes a difference, what helps you win, right?
Exactly. What in and of itself, I really think that's the key way of putting it. What circumstance or evidentiary theory or claim in and of itself can determine the outcome? And there always are between 3 and 6 for each side in every case. And so identifying those and then gearing your motions work your investigation in civil cases, depositions, discovery, all of that, to expanding what's good for you and narrowing what's good for them. That's how hard cases are won against the odds.
Wow. Very powerful idea. Thank you so much for sharing your wisdom with us today, Jim.
Thank you, Michael.